You who don't know me, my name is Tom Donnelly. I am our Senior Fellow for Constitutional Studies, and thank you so much for being here today. It should be a really fascinating discussion about the Civil War, Reconstruction, and American constitutionalism. First, just want to plug a few of the great programs that we have coming up. Next Tuesday night, we will have Barry Friedman, director of the policing program at NYU, their School of Law. He's going to discuss his new book, Unwarranted Policing Without Permission. Now, he's an extraordinary legal scholar, really engaging conversationalist. He also was a contributor to the National Constitution Center's Interactive Constitution, so he's a great friend of the center, and that should be a really terrific program. Later this season, we're also going to host some great discussions, for instance, on the future of the Affordable Care Act. We're also going to have Professor Jeffrey Stone, who's another great friend of the Constitution Center, come here to talk about his new book on morality and the Constitution. And then we also have an exclusive members event scheduled coming up on March 2nd. We're going to be hosting an opening party for the return of our exhibit on Prohibition called American Spirits, the Rise and Fall of Prohibition. And there we'll have a town hall program that's going to talk about the history of Prohibition, which should be really fascinating. So I hope you can join us. If you're not a member, please check out the members table out in the lobby, and you can learn about the benefits there. And right now, if you have a cell phone and it has not been silenced, please silence it. Now is the time to do that. So we're here now. It's obviously here at the Constitution Center, we're committed to celebrating the 150th anniversary of the Reconstruction Amendments, what we're calling our nation's second founding. And here we have one of the nation's great scholars on the Civil War, Reconstruction, and American constitutionalism, Professor Timothy Huebner. He is the Irma O. Sternberg Professor of History at Rhodes College. And his new book right here, which really is terrific. I highly recommend it. It's called Liberty and Union. It's also right here, actually. The Civil War Era and American Constitutionalism. There's going to be a book signing with Professor Huebner outside down in the lobby after the discussion, so please join down there. But I'm so excited to talk about this book, and thank you so much for being with us.
Thank you, Tom.
So you could talk about just a little bit, what was your impetus behind writing this book?
Well, it's a big book, and it's a book that took me a long time to write. It's a book that I hope tells a big story. I'm interested in what changed from the antebellum period to Reconstruction, and the only way to really evaluate that is to try to cover it all. So the book really explores American constitutionalism from the antebellum era through Reconstruction. And I try to tell the story then of Northerners and Southerners, and also those who have been traditionally left out of the constitutional narrative, and that is the constitutionalism of African Americans is something that I'm very interested in. And so I try to explore how all of those different perspectives on constitutional values play themselves out.
Terrific. Now, you begin the book with a terrific quote from Frederick Douglass, and one of my colleagues today reminded me that tomorrow is actually the observed birthday of Frederick Douglass, so I thought I'd read it aloud because I just think it's a superb frame for the entire book. I know of no soil better adapted to the growth of reform than American soil. I know of no country where the conditions for effecting great change in the settled order of things, for the development of right ideas of liberty and humanity, are more favorable than here in these United States. The very groundwork of this government is a good repository of Christian civilization. The Constitution, as well as the Declaration of Independence and the sentiments of the founders of the Republic, give us a platform broad enough and strong enough to support the most comprehensive plans for the freedom and elevation of all the people of this country without regard to color, class, and clime. Can you just talk a little bit about why you chose to lead off with that quote?
Sure. So one of the interesting things about that quote, and I stumbled onto it as I was about halfway through the book, is that Douglass says those words, writes those words in 1857, right after the Supreme Court's ruling in Dred Scott versus Sanford. So one would think that arguably this is the low point for African Americans, and that Frederick Douglass would feel like all hope was lost. And yet at that very moment, and this is just a few months after, I think this is from a speech that he gives in May of 1857, the Supreme Court issues its ruling in March of 1857, yet at that moment, Douglass really does believe that the Declaration and the Constitution can be and should be the foundation for black progress, and that it is still possible, and that it will be possible for slavery to end. And even more than that, as I try to tell the story, that African Americans will be able to gain rights. And so it's striking, the extraordinary sense of hope, and especially the faith in constitutional principles and founding values.
So why do you think it is that, and this is certainly present throughout your book from sort of different time periods and different parts of the country, but why is it that we as Americans, do you think, always return to our founders, both in our Constitution and in our political discourse?
Well, part of what I'm trying to show in the book is that especially in the middle of the 19th century, we have really what I call a constitutional culture. And if you think about it, I mean, we sort of typically try to separate these things. So we say there were the founders, and then we think about the Civil War, and we think of those as two very different time periods. And yet those who were part of these generations actually overlap. So the last living founder, James Madison, doesn't die until 1836, the father of the U.S. Constitution. Well, by 1836, Abraham Lincoln is already serving in the Illinois legislature. So Lincoln understands Madison. He knows of the founders. There's a famous book that came out a few years ago on Abraham Lincoln. It's called Founder's Son, right? So there's this extraordinary legacy that Abraham Lincoln and all of those of the Civil War era felt that they had inherited, and something that they felt that they needed to preserve. So in many ways, it shouldn't be surprising that we think about the Civil War generation, that they would be looking back to the founders as a sort of great group of men who had accomplished something extraordinary. And that's what they really thought.
Excellent. So we're going to, obviously, the book is quite ambitious, covers a lot of ground. I'd like to at least dip our toe into each period as best we can, and then everyone can pick up this book and learn more. But let's begin with the pre-Civil War period. And obviously, one of the key constitutional themes is how are we going to address slavery? And so, I mean, maybe just talk a little bit about, let's go from the South to the North and talk about the strains of thought in both of those areas. So beginning with the South, what are people saying? What are they thinking vis-a-vis slavery in the Constitution? Sure.
So slavery is one of the big issues that the founders arguably didn't really resolve. And what that means is by the 1820s and 1830s, but especially by the 1840s, there are two big issues in national politics that have to do with slavery. One is the fugitive slave issue, and the other, more significant, is the issue of the future of slavery into new territories. Will slavery be able to spread into federal territories, especially after the acquisition of areas from Mexico in 1848? So what this means is that Southerners start to, especially in the 1840s, start to think of slavery and slaveholding as encompassing a sort of bundle of rights. And so I use this term slaveholders' rights really throughout the first part of the book. And that's based on the idea that this is how Southerners talk about slavery and slaveholding in terms of their rights as property holders. So Southerners then are arguing that they have a bundle of rights. One is the right to hold slaves in the South. The second is the right to reclaim fugitive slaves in the North. And the third right that they're starting to argue for by the end of the 1840s is the right to take slave property into the West. Well, while this is happening, of course, what you see is a sort of growing opposition to this idea, but it is growing only slowly and gradually, and really not until the middle of the 1850s, not until after the Kansas-Nebraska Act of 1854, is there such opposition that a new, strictly northern political party is formed. That is, of course, the Republican Party, the party that Abraham Lincoln will, of course, end up joining. And that party is, of course, going to express opposition, especially to that third right, which is claimed by Southerners, which is the right to take slave property into the West. So that really turns into the major constitutional issue of the late 1850s, and it ends up in the Supreme Court in Dred Scott in 1857, where the Supreme Court tries to resolve especially that issue of the rights of slaveholders in federal territories. Roger Taney, a very interesting character whom I've studied, Maryland slaveholder in his early years, freed all of his own slaves early in his life, uttered some anti-slavery words when he was practicing law in 1819 and 1820. But by 1857, he's been on the U.S. Supreme Court since 1836, and he really is arguably a creature of the very pro-Southern, pro-slavery Democratic Party. And Taney has grown more and more pro-slavery in his old age. And by 1857, Taney's pro-slavery views especially come out. He's one of 7 justices in that case who actually ruled that slaveholders' rights are absolute. Taney finds a right to hold property and to take that property into the federal territories in the U.S. Constitution, even though that's never explicitly stated there. And so that's sort of how and why and where the sectional crisis is by 1857. It's this Southern notion of slaveholders' rights. And frankly, when I first started to use that phrase, I was a little bothered by it because it's difficult now in the early 21st century for us to stomach the idea of slaveholders thinking that they had rights. But that's how they thought about it. So slaveholders' rights on the one hand, and on the other hand, this sort of view of the Constitution that really argues that the founders had intended to put slavery, as Lincoln put it, on a course of ultimate extinction. So that really is the clash by the end of the 1850s.
And then with Dred Scott, we get Lincoln really entering the national scene. Can you talk a little bit about how Lincoln himself was, how he relates to the anti-slavery tradition that came before him, and sort of give us a sense of where his constitutional views and visions stood as we're on the precipice of the Civil War?
Right, so Lincoln is, of course, central to the story and to the book. He's fascinating, endlessly fascinating. The saying is that there have been 16,000 books written about Abraham Lincoln alone. Hard to fathom. But Lincoln plays a critical role in so many ways. He's personally anti-slavery. As early as the 1830s, we see evidence of that in Lincoln's writings. He makes anti-slavery comments while he's serving in the Illinois legislature. So we know that he has these personally anti-slavery sentiments that have deep roots. At the same time, Lincoln is a constitutionalist. He believes in the Constitution, and if you go back to his earliest speech, the Lyceum speech, which he gives in Illinois back in Springfield in 1838, he speaks over and over again of reverence for the laws. And unlike most other sort of lawyer politicians of the era, Lincoln actually spent a great deal of his life practicing law. And so over and over again, we see in the words and speeches of Abraham Lincoln this emphasis on upholding law. And the Constitution then ultimately is supreme law. And that's how Lincoln sees it. So there's a tension there. Because Lincoln, who's personally anti-slavery, and Lincoln, who's a constitutionalist, has to deal with the fact that the text of the Constitution seems to uphold at least the rights of slaveholders to reclaim fugitives. So there's the fugitive slave clause. And Lincoln doesn't quite know what to do with this. When he's sworn in as president in March of 1861, he seems to acknowledge 2 of those 3 rights that had been claimed by Southern slaveholders. He acknowledges that he's not going to interfere with slavery in the South, and he had said that over and over again while he was arguing with Stephen Douglas in 1858. And he also says he's going to uphold the fugitive slave law. And he basically boils down the entire sectional issue to this 3rd sort of right, which is this issue of whether Southerners can take slaves into the West. And on that point, Lincoln is adamant that he does not believe in the spread of slavery. And in making that argument, once again, he believes he's carrying out the wishes of the founders. So Lincoln then, as a legalist and a constitutionalist who's anti-slavery, has to come to terms with that, and that doesn't happen until he's president, and a whole set of circumstances in war will sort of shape Lincoln's thinking at that point.
All right, so we've placed the South on the table, the North, Lincoln. Before plowing into the Civil War, can you talk a little bit about the tradition of constitutionalism within the African American community in the pre-Civil War period?
Absolutely, and that is a big part of the book. So one of the things I'm arguing for is the existence of black constitutionalism, and it is this idea that you mentioned earlier in the Douglas quote from 1857. That African Americans, not just Douglas, not just in the 1850s, but arguably really going all the way back to the 1790s, just after the ratification of the U.S. Constitution, African Americans claim these promises for themselves. They claim the promises of the Declaration and the promises of the U.S. Constitution. And they see themselves in these texts in the sense that they look very carefully at the Declaration, and it says all men are created equal. They look very carefully at the U.S. Constitution. It starts out with the words, we the people. They also notice that the word slavery or slave is never actually used in the text of the U.S. Constitution. And what that means from their perspective, adding to the idea that many of them are sort of coming out of a Christian theological tradition in which they believe that rights come from God. If you add all that up, what you see really as early as the 1790s in a petition put forth by Absalom Jones. Absalom Jones is the first black Episcopal priest in the United States. He's the leader of free blacks in Philadelphia. He and others issue a petition to Congress claiming these promises in the Declaration and in the U.S. Constitution. And in this statement that they issue, they're expressing their opposition to the Fugitive Slave Clause and any federal law that would try to sort of put that into practice. Really from that point on, there is this notion based on the Declaration, based on the idea that the word slavery is never used in the text of the Constitution, that African Americans look to the founding and the founders to try to claim those promises for themselves. And I argue really that black constitutionalism really is a sense of both belonging and aspiration. Belonging to the United States, belonging to the Republic, and yet aspiring that the Republic can and should be something better and greater. Holding it to a higher standard, holding it to the standard of the Declaration of Independence. And so that is a theme that runs really throughout the book, this notion of black constitutionalism.
So now bringing that forward into the Civil War as a transition, I mean, can you talk a little bit about the degree to which African Americans in both their words but also their actions by serving in the military, by fleeing from plantations, et cetera, played a key role in securing their own emancipation?
Right, absolutely. And this is a very significant point, and scholars have written a lot about this in the last 20 years, how African Americans take matters into their own hands if you look at what's happening on the ground during the Civil War. So for years and years, we told the story of Abraham Lincoln as kind of freeing the slaves with the stroke of a pen. Obviously, Abraham Lincoln is central to the whole process. But it's not just Abraham Lincoln. It's those in Congress who are also passing laws to try to interfere with slavery, to end slavery. So Congress, as early as 1862, is banning slavery in Washington, D.C. They're passing legislation ending slavery in the territories. They're overturning the fugitive slave law. So Congress and Lincoln are working in tandem as early as 1862. Lincoln signing a series of laws known as the Confiscation Acts in 1861 and 1862 that are starting to chip away at the institution of slavery, not only in places like Washington, D.C. and territories, but also slaves who were held by rebels. But Also, at the same time that all that's happening in Washington, D.C., what's happening in the South as the war is unfolding is that African Americans are taking matters into their own hands. They are, of course, seeing the enemies of their masters as their friends, and that means that from the start, African Americans see this as a war to end slavery, even though Lincoln isn't speaking of it yet in those terms, and he'll not really speak of it in those terms until fall of 1862. But in early 1861, even prior to the outbreak of the war in April, some African Americans are already fleeing to places like Fort Sumter, which are still federally held. Ultimately, they'll flee to Fort Pickens, but also to Fortress Monroe, which is a federal occupied fort in Virginia. So African Americans early on are making these efforts on their own to seek freedom. And then, of course, they'll see federal military lines once the war really is being fought in earnest after the Battle of Shiloh in April of 1862. Really, it's clear at that point this is a war that is going to last a long time. It's going to be a hard war. A lot of people are likely to die. And it's at that point that African Americans really start to walk off plantations and into situations where they know that they will be protected by the federal military. And let me give one example from my part of the world. I'm from Memphis, and a very huge part of the African American population in the South held as slaves in the Mississippi Delta, just south of Memphis. Well, Memphis is a federally occupied city after the Battle of Memphis in June of 1862. And so at that point, Sherman occupies Memphis for the next several months, and really from that point on, Memphis is in federal hands. Well, Memphis is very close to these Mississippi Delta plantations. And what happens over the period from the start of the war till the end of the war is the African American population of Memphis is going to quadruple from about 4,000 to 16,000. And those are formerly enslaved people who are seeking freedom in Memphis. But the same thing is happening in Nashville, New Orleans, Baton Rouge, all of these federally occupied cities. And of course, federal military victories happen in the West earlier than they do in the East. All of these cities, once they fall into federal hands, will be they will be serving as havens for people who are seeking their freedom. So yes, African Americans play a critical role here in helping to bring about freedom. And that process is certainly aided by Abraham Lincoln's Emancipation Proclamation on January 1st, 1863. That means then, of course, that what has already been happening on the ground will happen even more so.
And one of the key themes you talk about in the Civil War and with Lincoln that runs through with the Emancipation Proclamation, but also with the suspension of habeas corpus, for instance, is Lincoln's assertion of presidential power during the war. Can you talk a little bit about how President Lincoln used what he saw to be his war powers to promote Union victory in the Civil War, and what that suggests about the scope and limits of presidential power generally?
Yeah, that's a great question, and it's something that I think Lincoln struggled with, and scholars have struggled with really over the decades, because many of Lincoln's actions are unprecedented. If you think about his predecessor, James Buchanan, Buchanan thought he had no power at all to deal with the secession crisis. So we fail to realize sometimes that a secession happens, or 7 of the states actually try to secede while Lincoln isn't even yet president. Buchanan sits by idly and does nothing. He says, I have no power to intervene in this situation. And so that's what he does. He does absolutely nothing. Abraham Lincoln comes at it from a very different point of view. He swears the oath of office on March 3rd, 1861. He says, I have an oath registered in heaven to preserve the Union. He says in his first inaugural speech, the essence of secession is anarchy. I cannot let this happen. I, as president, am sworn to uphold this Constitution and to preserve this federal union. So I can't simply let it fall apart. So he takes action. And I argue really that this is also rooted in his deep attachment to the Constitution. Because he believes it's almost a sacred document that has established this sacred union, Lincoln thinks of it in those ways. So he takes that oath very seriously. So that means he takes extraordinary steps, right? It means that early on, he's willing to suspend the privilege of the writ of habeas corpus, a controversial measure at the time. But if you read how Lincoln writes about that in the summer of 1861 in his first message to Congress, what he says is, he says, the cause of the Union is the cause of freedom. And here Lincoln's anti-slavery sentiment seeps into this document, even though it's not federal policy yet that this is a war to end slavery. But he frames things as the cause of the preservation of the Union, actually the sort of cause of free labor ideology. Free labor ideology is the ideology of his party in the 1850s, arguing that really freedom comes about when you lift burdens from the shoulders of men and let them work for wages and for the best wage that they can get in the marketplace. This is a very significant part of why Lincoln is opposed to slavery, because slavery is the opposite of this free labor system that he's writing about and he's advocating. So Lincoln argues then ultimately that only by preserving this union are we going to be able to preserve and to promote freedom. And so already in the summer of 1861, he's linking those things, kind of in subtle ways. He won't link them fully until the Gettysburg Address in the fall of 1863. But that's what he's thinking about and he's struggling with. So yes, he exercises extraordinary power, a power that was unprecedented, and that's especially true with the Emancipation Proclamation, a landmark document and a big part of the book. What Lincoln is doing there is stretching presidential power to its limits. But at the same time, Lincoln thinks he has more power to liberate slaves in the South than Congress. And so we sort of, typically say, when we look at Lincoln's Emancipation Proclamation, that it was too narrowly drawn, that it was legalistic, that he only was liberating those slaves technically that he wouldn't have power to liberate because the proclamation applied only to the Confederacy. And yet, of course, Lincoln thinks that that's where his power is greatest, because as the commander-in-chief, he's arguing his power is strongest in those areas that are still in rebellion against the government of the United States. And so, yes, he's arguing for a strong sense of the power of the presidency in order to end slavery in those rebel states. Certain areas that were already under federal occupation are exempt from Abraham Lincoln's Emancipation Proclamation, but arguably slavery in some ways had already ended there. So all that then is simply to say that, yes, Emancipation Proclamation fits with this aggregation of executive power, but it's always in Abraham Lincoln's mind in order to preserve the Union and ultimately to preserve this notion of freedom.
And so Lincoln and the Republican Party are they're fighting to preserve the Union. At the same time, you discuss what's happening down south with the Confederates and Jefferson Davis trying to build their own nation at the same time. What do we learn from the Confederate Constitution and the debates and rhetoric down there about the degree to which what they conceive themselves as doing as sort of continuing an older tradition versus breaking free and starting anew?
Yes, and there really has not been a lot of scholarship done on kind of Confederate constitutionalism or how Southerners during the war looked at the Constitution. So I think that's in some ways one of the areas where I break some significant new ground. The Confederate Constitution is 95% from the U.S. Constitution. It's almost exactly the same document. But that other 5% is very significant. And so that shows a couple of things. One, it shows, once again, as the whole theme of the book is constitutionalism and this constitutional culture, that Southerners were part of that constitutional culture. And they had a deep reverence for the founders. They thought they were acting in the spirit of the founders. They saw themselves as the heirs of the revolutionary generation. George Washington is the figure who's at the center of their national seal. George Washington's birthday is the day on which Jefferson Davis was going to take the oath of office. So there's all that symbolism associated with Virginia and the founding and the fathers and all of that. So yes, there's constitutionalism and sort of reverence for the founding text. At the same time that they thought that the founders didn't get some things right, and they wanted to change those things. The biggest thing, obviously, was slavery. So we go back to the Constitution of 1787, the word slavery is never used. And the fact that it had never been used meant that there was some ambiguity on that question, which is why for the next 70 years people are arguing over the institution of slavery. So Confederates want to end any ambiguity at all by making it crystal clear in their founding text in 1861 that slavery and slaveholders' rights, as they understood it, would be protected. So while the U.S. Constitution never mentioned slavery, the Confederate Constitution of 1861 mentions slavery several times, I think 6. And most specifically and significantly, they include a statement saying that the right of property in Negro slaves cannot be interfered with. So they do a couple of things there. They say that there is a right of property in slaves, which Madison had said we will not write into the Constitution back in 1787. And then they also racialize it by making reference to Negro slavery. So it's slavery written into the text, and it's black slavery. So there's no doubt as to what these states stood for. In my part of the country, people sometimes still argue over this. You still have folks in the South who argue that Southerners didn't secede necessarily to protect the institution of slavery. But if we look at the founding texts of the Confederacy, it's crystal clear that they were trying to protect the institution of slavery and the rights of slaveholders. They do make some other changes that are very significant in their own founding document. They say that their Confederacy is based on the principle of state sovereignty. So they mention the sovereignty of the individual states in the preamble. Jefferson Davis quickly learns that it's very hard to mobilize a central government if you're going to champion the principle of state sovereignty. And of course, he runs into all sorts of problems with various governors, especially Joseph Brown of the state of Georgia, in their opposition to President Davis's attempts to instate a military draft, for example. So it's very hard to mobilize your people to fight a war if your Constitution seems to highlight the principle of state sovereignty.
So we've covered the pre-Civil War period, the Civil War period. Let's speed ahead here to Reconstruction, which is obviously a fascinating topic. Can you just talk a little bit about what were so Lincoln's assassinated, President Johnson becomes president. We have congressional Republicans. What was at stake really in sort of the competing visions of Andrew Johnson Reconstruction versus congressional Republicans?
Right. Well, so much was at stake because Reconstruction is the time during which the nation had to figure out what the war actually meant. And it's one of the great tragedies, really, that there's so little scholarship on Reconstruction. Everybody wants to write about the Civil War and talk about the war, this period from 1861 to 1865. There ought to be a whole lot more folks writing about the Reconstruction period, I think, because Reconstruction is where we have to decide what the war means and what will be the outcome, what are the consequences. Why does it matter? And so what's happening after the war and after the death of Abraham Lincoln specifically is everyone in the North and even most in the South are willing to acknowledge by 1865 that slavery has ended. So we have a 13th Amendment. Andrew Johnson is a great champion of the 13th Amendment. Johnson's personal transformation on this issue in some ways is striking. He had owned a small number of slaves back in Tennessee, but ultimately serves as wartime governor of Tennessee. He ends up as vice president running with Lincoln in 1864. Johnson comes to realize, as Lincoln and so many others did, that the best way to make sure that there's never a sort of continuation of the Civil War or the sectional crisis is to end the cause of it, right? And that's to end slavery. So Johnson becomes a champion of the 13th Amendment. And he celebrates the 13th Amendment as the greatest achievement in the history of our country. And he says so. For Johnson, that was the end. That was Reconstruction. So you end slavery, and then you allow the southern states to come back into the Union on easy terms, and you reestablish civilian government, and that's what Reconstruction looks like. That's not how many in the North, and it certainly is not how African Americans saw things, because African Americans, from the start, as we said, not only saw this as a war to end slavery, but as they're fighting, and I mean, I should point out that ultimately 200,000 African Americans fight in the Union Army or Navy. As this fighting is happening, African Americans make it very clear that they're fighting to end slavery, but they're also arguing that they deserve citizenship. And what comes with citizenship is rights. So you have Johnson on the one hand, who says that Reconstruction is basically the end of slavery and bringing the southern states back into the Union as quickly as possible. And you have African American activists and their allies in Congress, really, a significant number of them, by 1866, 1867, are arguing for civil rights. And that means a 14th Amendment and ultimately a 15th Amendment. And so what's at stake really is the meaning of the war, and especially the meaning of freedom. Is freedom simply the absence of slavery for those 4 million people who had previously been held as slaves? Or is the meaning of freedom really citizenship and rights and all those notions that black constitutionalists had been arguing for from the earliest days, right? A sense of citizenship and rights, a sense of belonging to this country, and that sense of aspiration to make sure that the country lives up to its founding principles. And so that's really what's going on. It's Johnson and Congress. African American activists are also players there to an extent, and trying to work out all of that is the essence of Reconstruction.
And so, you know, here we've often described the 13th, 14th, and 15th Amendments as a second founding of our nation. That's sort of our frame here at the National Constitution Center. To what degree do you think that frame's right, or would you qualify it?
I think that frame is right. I think the changes that come about during Reconstruction are profoundly significant. And part of what I argue is that those rights in the 14th and the 15th Amendment were implemented and enforced for a longer period of time than we typically think. We typically put the end of Reconstruction as 1877, and that's kind of the sort of the date that we use, right? Even those of us who teach American history, you know, you split it into two halves. The first half is to 1877, and the second half is since 1877, based on this idea that that was when Reconstruction ended. And yet it is arguably a lot more complicated than that. If you look at the extent to which the federal government is invested in enforcing these civil and political rights in the 14th and the 15th Amendment. And they're willing to enforce those rights beyond 1877. I have a chart in the book, and I have a series of tables that show the numbers of cases that actually are brought into federal court by the federal government. So this is under President Grant, but even after President Grant, under President Hayes and the presidents who follow in the 1880s. Reconstruction in that sense, if we think about it as what the 14th Amendment and the 15th Amendment mean, those things are carried out a little bit longer than we typically say. But more than that, I mean, even if you were to set aside the 14th and the 15th Amendment and set aside the question of to what extent the federal government is invested in trying to make sure that those have real meaning, the 13th Amendment is profoundly significant, and we shouldn't overlook that. The 13th Amendment means that the fact of freedom on the ground is real for African Americans. And I spend a part of a chapter there in the Reconstruction section focusing on the meaning of black freedom. And black freedom means the possibility for movement. It means the possibility to enter into contracts and earn wages. It means the possibility to form churches and to worship freely. It means the possibility of bringing cases into court. And there have been recent studies that show that African Americans who bring a series of cases into civil courts in the 1870s, and 1880s are actually winning those cases. So these are things that are happening on the ground that aren't necessarily rooted in the 14th and the 15th Amendment, but that have to do with the sort of basic rights associated with being free. And so in the end, I argue that the war was revolutionary, if for no other reason than the fact that freedom is now the central organizing principle. And the shift, even when it comes to rights, is even more significant. And that shift is the shift from the rights of slaveholders at the center of the antebellum political, debate is the rights of slaveholders. After the war, we're no longer, even thinking about the rights of slaveholders. After the war, we're thinking about the rights of all of those people who had previously been held as slaves. And that is a new, fundamentally different sort of discourse of rights. That's very significant.
Excellent. So we have some great questions from our audience, which we'll turn to right now. Here's the first one, sort of, I think it dovetails with what you were just saying. Did slaves have any constitutional or statutory rights in the antebellum South?
In the antebellum South, slaves had some rights, but they varied from state to state. So if you look at the question of slave law and whether slaves have rights in court, there have been a number of studies on this, and there's really quite a bit of variation, state to state, judge to judge. There were certain judges who constantly were making references to the humanity of the slave and trying to guarantee some procedural guarantees in terms of how slaves' cases would be handled. At the same time, there were many other places, and you can think of certain judges, specifically Judge Thomas Ruffin in North Carolina in the 1820s. In 1829, in a famous case called State versus Mann, argued that the power of the master had to be absolute in order to render the submission of the slave complete. So there's a lot of variation over time and space and by individual judges. But if there's one thing to think about in terms of the rights of slaves in the antebellum period, it's that most slaves never saw the inside of a courtroom. Most slaves' cases never made it into court. And only when there were a specific set of circumstances would that actually happen. Now, there are certain circumstances where those cases do go to court, and slaves' procedural rights are upheld by the courts, but mostly it's a story of African Americans not really having very many rights at all, because on most plantations, the master serves as the law and the judge and the jury.
Did women also, like African Americans, believe that the Constitution applied to them too, especially in regard to voting rights?
Yeah, so this is one of the interesting parts of the story that I kind of touch on at a few points. I don't go into this in any great depth. Maybe that's another project, but others have obviously written about this. But women, in many ways, see what happens during Reconstruction as a lost opportunity. Because what happens is, in the 14th Amendment, for example, for the first time, in that part of the 14th Amendment that deals with black suffrage in the reconstructed states after the war, for the first time in the constitutional text, the word male is actually used, restricting suffrage to men in the South. So this is in, I think, Section 2 of the 14th Amendment, which has to do with overturning the 3/5 clause and figuring out how states will have representatives in the Congress after the war. And there's this reference to male inhabitants. So that's a setback for women. At the same time, women do bring cases into court in the 1870s to try to figure out if the first section of the 14th Amendment applies to them in terms of voting. In other words, is voting one of those privileges and immunities in Section 1 of the 14th Amendment that cannot be interfered with by the states? The Supreme Court rules in that case and rules that women's voting is not one of those constitutional rights at that point. Of course, we know that that changes, but it takes another, almost 50 years. So.
To what extent do we view Lincoln's suspension of the writ of habeas corpus and other unprecedented actions favorably because the Union won the Civil War?
That's a great question. And it's one that I struggle with. It is one that I think all of us in some way struggle with. Lincoln famously said after the suspension of the writ, he said, in so many words, he said, look, should I allow the whole Union and Constitution to go to pieces just so I could say that I protected the privilege of the writ of habeas corpus? He says, must all the laws but one go unenforced in order to uphold this one law? So he is basically saying that if we want to have any rights at all, we've got to protect this federal union, and that's what is being threatened. So what that leads to, as I said, is a very expansive view of presidential power. But we should understand it's presidential power in the context of a civil war. And the Constitution itself did make reference to the suspension of the writ of habeas corpus in times of rebellion. This is in Article 1, Section 9. Now, Chief Justice Taney doesn't think that the president has the power to suspend the writ. He thinks only Congress has that power. But Lincoln's point is that the Constitution does make a distinction between suspension of the writ in time of rebellion and not, and does think that there is cause for it in such a case. So Lincoln, again, thinks deeply about this issue. He thinks about the preservation of freedom. He thinks about that oath that he has registered in heaven to protect this Constitution and the federal union. All of that goes into his act to suspend the privilege of the writ, which I should point out is accepted by Congress once they come into session several months later. So we shouldn't necessarily see this as Lincoln acting on his own. He does have the support of Congress for so many of his policies.
Is not President Buchanan's refusal to act more a reflection of his sectional politics than a pure reading of his constitutionalism?
Yeah, that's a good question. Buchanan is a Democrat. He's one of these northern doughfaces. This is the term used at the time to describe northerners who acted like southerners, who were very interested in protecting southern rights and slaves. Buchanan is a Democrat from Pennsylvania. He acts like a lot of northern Democrats at the time. I should add that of the 7 justices on the side with Chief Justice Taney and Dred Scott, 5 of them are from slaveholding states, but 2 of them are from northern states. They're both Democrats. So Northern Democrats upholding Southern principles and the rights of slaveholders, that's definitely part of the story in the 1850s. That's basically the story of the career of Stephen Douglas. He had been kind of an advocate of Southern rights and a defender of Southerners for many years. What happens with Douglas is that he sees that the goalposts are being moved because Stephen Douglas, of course from Illinois, argues for the notion of popular sovereignty, which is this whole idea that on the whole issue of whether slavery ought to spread into the West, it ought to be left up to the settlers who end up out in the West. That was a fine stance to hold, and Southerners were in favor of that in the late 1840s and early 1850s. But by the end of the 1850s, Southerners were saying, no, we don't really want popular sovereignty. We want you to guarantee the actual rights of all slaveholders in these territories. And by that point, Douglas loses some of his friends in the South. So it's kind of an interesting political game that these Northern Democrats are trying to navigate in terms of trying to win enough support in the South in order to win the presidency at the same time that they're able to hold on to enough states in the North. Buchanan is the last Democrat who's able to do that because he wins those states of the lower North that 4 years later Lincoln will end up winning when he's elected president.
Now we see Lincoln sandwiched in between Buchanan and Johnson, 2 presidents who historians usually aren't too kind to. What do you think about those evaluations of Buchanan and Johnson? And I don't know, it's just sort of it's a weird succession, really.
Right, it is. And frequently there are lists that come out of the greatest presidents and the worst presidents, right? And inevitably, of course, Lincoln is at the top of the greatest list, and at the worst list, you always see Buchanan and Johnson. And it is striking. And I think it has everything to do with how they responded in this time, in this context. Because Buchanan did nothing, and for other reasons, I mean, he kind of put the U.S. Treasury in a horrible position. When Lincoln came into office, there was all sorts of debt and all sorts of financial problems that Lincoln and Congress found themselves having to sort of clean up. But I'm most struck by the contrast between Lincoln and Johnson, because Johnson gets none of Lincoln's glory and Lincoln gets none of the tarnish associated with Andrew Johnson. And yet here's a president and vice president who were linked to each other. They're on the same ticket in 1864. And arguably, part of Johnson's Reconstruction policy, how he treated the South and really wanted to bring them into the Union as quickly as possible, is Lincoln's policy. It's the question of the rights of African Americans, I think, where they would have differed very strongly. So I'm often asked, well, what would have happened if Lincoln had actually lived? And I think that probably there would not have been the intense showdown with the radicals in Congress. Lincoln would have been better at dealing with radicals and figuring out a way to enact the 14th Amendment that perhaps would have been less offensive to Johnson or all those whom Johnson represented, the interests of Southerners, and probably that process would have been a lot more smooth, and Reconstruction may have turned out differently. Now, I mean, all that speculation, and of course we will never know, so I can, in effect, say anything, right? But it is still interesting to me that given that Johnson would have implemented, or Johnson did implement much of what Lincoln would have implemented, that we see them in such starkly different terms, and that we never pair them together. I mean, we never put them kind of in the same group. Although it's interesting that Seward is the Secretary of State under both Lincoln and Johnson, and there's a continuity there represented by Seward's policies toward the South. So we might speculate that had Lincoln lived, some of those same policies would have been implemented. So it's interesting to think about that. Of course, we can never really know for certain.
In your discussion of the quote-unquote contrabands, did you mention that during our discussion here, you did not mention the initial refusal of the Federal Army to allow them entry into their lines. Does that fact matter?
You're right, absolutely, yeah. So this is a big shift in federal policy. So in 1861, when African Americans are seeking freedom behind federal military lines, so when African Americans make their way to Fort Pickens in Florida and Fort Sumter in South Carolina, they are sent back to their owners. That changes once the war begins. It changes because federal policy changes. It changes because of General Benjamin Butler, who's at Fortress Monroe in the summer of 1861, after Fort Sumter, after the war has already started. Butler is in charge there at Fortress Monroe, which is a federally held fort in Virginia. And what happens is a local slaveholder comes to General Butler and claims that his fugitives have escaped to Fortress Monroe, and he wants them to be returned under the federal fugitive slave law. Well, Virginia has already left the Union at this point, and so Butler kind of scratches his head and he kind of thinks about it. Butler, in addition to being a general, is also a lawyer, and he says, no, I don't think we're going to send these slaves back to you, because how can you claim that the federal fugitive slave law is in force if you've claimed to have left the federal union? So we're not going to send them back. We're going to claim them as contraband of war. And that's the legal and constitutional principle then that takes hold at that moment in the summer of 1861 that starts to serve as the basis for Lincoln's Emancipation Proclamation and makes possible the other federal efforts, the federal laws passed by Congress to start to interfere with Southern slavery. Yes, it's very significant that federal policy shifts once the war is in place.
Could an economic model other than slavery have produced the same or better financial results in the South?
Could an economic model other than slavery? Well, I'll leave that to those who study economic history. Those who have written about the economics of slavery argue that it was a profitable system, and I'm going to answer this by going to Reconstruction, actually. What happens after the war is that African Americans are able to a great extent, are able to take control of their own labor. And that means that they, through the system of sharecropping, are able to work the hours that they want. And that means that they end up reducing their hours because they're working for a share of the crop. So they have more freedom and autonomy to, in many instances, not everywhere, but in many instances, to decide which crops to grow and how much to work. And what ends up happening is that the labor expended by African Americans drops. So all that then is simply to say, under the system of slavery, which is a brutal system, right? Southern slaveholders are trying to get all that they can out of slave labor. They are trying to maximize profits. Sort of coming back to the question, my sense is that Southerners profited greatly from the institution of slavery, and had a system of free labor been in place as opposed to slavery, that Southern slaveholders would not have been able to acquire the enormous wealth that they did. I mean, if you think about some of these Mississippi planters in the Mississippi Delta, for example, I mean, these are some of the wealthiest people in the whole world, and they've made that money on the backs of slaves.
And we'll end let's end with a question sort of where I ended the Q&A, and on an optimistic and grand note. Is the U.S. Constitution a fundamentally different document after the Reconstruction Amendments?
I think it is a different document. Really, we moved from a pro-slavery constitutional order to a post-slavery constitutional order. And once again, that changes how we think about rights. It creates this new discourse of rights. It's during the Civil War that we first start to think of human rights. And that phrase is used by African Americans, by these black activists whom I've been talking about. Prior to the war, they are claiming citizenship and rights for all people. And that is the discourse that takes hold after the war. And that's profoundly significant, once again, if we think about this antebellum pro-slavery constitutional order upheld by the Democratic Party and by the Supreme Court, Chief Justice Taney, 7-2 ruling in Dred Scott in 1857, that slaveholders' rights were absolute. And then if we think about the other part of Taney's ruling in that case, it was that African Americans had no rights. So we go from African Americans having no rights and slaveholders having all of the rights to, after the war, a fundamentally different situation. That's a revolution, and that's what I write about in the book.
Perfect way to end. Let's give a warm National Constitution thank you to Timothy Huebner. Thank you so much.
All right.